Welcome back to Day 3 of the ACS National Convention. I'm Megan Paulus, Vice President of Network Advancement for ACS.
And I'm Peggy Lee, Director of Chapters for ACS. We're thrilled to be here with you today, with you all, even virtually, to recognize our Lawyer Chapter awardees and National Student Writing Competition winners.
We'll start with the Constance Baker Motley National Student Writing Competition. Every year, ACS, along with the University of Pennsylvania ACS Student Chapter, selects and awards the strongest paper furthering and promoting a progressive vision of the Constitution, law, and public policy. This year's runners-up are Paige Britton of Drexel University School of Law and Megan Hauptman of Yale Law School. This year's winner is Patrick Burning O'Neill of the University of Chicago Law School for his paper, A Reasonably Comparable Evil, Expanding Intersectional Claims under Title VII Using Existing Precedent. Patrick will receive an opportunity to publish his paper in the University of Pennsylvania Journal of Constitutional Law and $3,000. Congratulations, Patrick. Our student and lawyer chapters are the heart of ACS. They bring together progressive law students, lawyers, scholars, judges, policymakers, activists, and others in communities across the country. In the last year, our chapters hosted over 1,000 programs virtually on a wide range of topics, working to make a positive difference both nationally and in local communities. Encourage your friends and colleagues to get involved in ACS. If there is no chapter in your area, contact us and we'll help you build one.
Now, we want to take time to recognize a few of our outstanding lawyer chapters. I'm honored to present the Minneapolis-St. Paul Lawyer Chapter with a Programming Award to recognize its impactful year. The Twin Cities Lawyer Chapter's programming demonstrates a strong commitment to racial equity and expanding the progressive legal network. The chapter organized more than 15 events and worked to create space for the progressive legal community to organize in response to the murder of George Floyd and the trial of Derek Chauvin. The chapter also works diligently to support the ACS student chapters in Minnesota. So congratulations to Rachel Kitsey Collins, Adam Miller, and the entire Minneapolis-St. Paul Lawyer Chapter Board. I'm also excited to recognize our Washington, D.C. Lawyer Chapter with a Programming Award for the second year in a row. The D.C. Lawyer Chapter held over 24 events in the past 12 months, covering topics that included path to the bench, court reform, impeachment, gun violence prevention, and antitrust. The chapter organized a series of events on sovereignty and status, including robust discussions on statehood for the District of Columbia and tribal sovereignty. The DC Lawyer Chapter played a leading role in using the virtual environment to collaborate with other lawyer chapters from across the country to shape debate and make a difference. Congratulations to Hirsch Verngadi, the chapter's chair, and the entire Washington, D.C. Lawyer Chapter Board. I'm honored now to present our Lawyer Chapter of the Year Award to the Florida Lawyer Chapter Network, which includes chapters in North Florida, South Florida, Central Florida, and Tampa. Our Florida Lawyers and Chapters Network demonstrates a strong commitment and dedication to expanding and advancing the progressive legal network in Florida, working together to strategically build relationships throughout the state and foster a path to the bench for progressives in the state. Florida chapter leaders have even trained other chapters on how to effectively strengthen their statewide networks. Simply put, the chapter has done a phenomenal job of creating a constructive dialogue for change and advancing the progressive network in Florida. Congratulations to our Florida leaders, Rashad Green, Kevin Golubieski, Fallon Pierre, David Karp, John Reed, Marie Mason, Michael Barber, and to all of our Florida Lawyer Chapter leaders for earning this well-deserved award.
A little over 2 weeks ago, we had the opportunity to honor our ACS student leaders during our virtual graduation. It was clear that our student chapters across the country have built powerful networks. That would not be possible without support from great faculty advisors. So now I'm excited to announce our Faculty Advisor of the Year awardee. This award goes to an ACS faculty advisor who has gone above and beyond to support their chapter, empower student leaders, and strengthen the ACS network. This year's awardee is Professor Sharma Murthy, Associate Professor of Law and Director of Faculty Scholarship and Research at Suffolk University Law School. Professor Murthy has impressed us with her dedication to supporting the student chapter leaders at Suffolk Law. Additionally, she worked to support the nationwide student network, speaking at not one, but 2 virtual student conventions during the pandemic. In addition, Professor Murthy has been deeply engaged with ACS National for many years by actively participating in faculty advisor gatherings, writing for ACS publications, including most recently about the Paris Agreement, and engaging with lawyer chapters. Congratulations to this year's winner, Professor Sharma Murthy. We're honored to work with you and grateful for your contributions to ACS's mission.
Congratulations to all of our winners. It is now my pleasure to pass the mic to Jacob Remus to present the David Carliner Public Interest Award.
Thank you very much for that introduction. The David Carliner Award honors rising stars in public interest and movement law who work in immigration rights, civil liberties, or human rights. It is a memorial to a pioneer in immigration law who is also a creative advocate in the struggles against Jim Crow, for gay rights, and for DC home rule and voting rights. This year, the distinguished panel of judges had their work cut out for them. They named 2 extraordinary finalists. Amir Ali, the brilliant appellant litigator and strategist for indigent criminal defendants, who founded and directs the Washington office of the MacArthur Justice Center, and Chase Strangio, the inspiring organizer, strategist, and lawyer behind so many of the ACLU's victories defending trans youth. If those are the finalists, you'll know that the winner of the 2021 Carliner Public Interest Award must be truly exceptional. Adaku Onyeku Crawford is the Director of Educational Equity at the National Women's Law Center in Washington, where she has built an intersectional practice of organizing, education, lobbying, and litigation to demand the rights of Black and brown girls in schools, or, more to the point, to help Black and brown girls in schools demand their own rights. The great poverty lawyer Jack Anderson taught that lawyers and movements should be, quote, on tap, not on top, and that idea is at the center of Adaku's work. She works with middle and high school students and puts her skills and her training to use for them as they find helpful. She helped create toolkits that explain federal civil rights laws to middle school students so that they can demand their own rights. She spoke to Black and Latina girls in the District of Columbia schools about the sex and race discrimination they faced, helped them generalize from their experiences, and wrote with them a report that treated them, as she has written, quote, not as subjects of study, but as experts in their own experiences capable of proposing solutions to the barriers they face, end quote. The DC Council cited the report that Adaku co-authored with these students when they passed comprehensive school discipline reform. In Virginia, Adaku insisted that high school students be included in meetings with state legislators so that they could describe how their schools police their clothes and their bodies, and so that they, the students, could demand the solutions that made sense to them. She organized partnerships with local organizations and built strong relationships with state delegates, with one state delegate in particular who sponsored the legislation. And last year, thanks to Adaku's strategizing, organizing, research, and advocacy, the Virginia legislature passed and the governor signed a first in the nation Dress Code Equity Act. Adaku Onyeku Crawford is a model of public interest lawyering. Her litigation, her legislative advocacy, and her organizing are based on an intersectional analysis that highlights how Black and brown schoolgirls' experience is shaped by overlapping misogyny and white supremacy. And crucially, she does not identify problems and seek as a lawyer to solve them. Rather, she helps the students identify their problems and help them solve their problems. She places the students themselves at the center, using her talents to help them build power for themselves. It is my great pleasure to give ACS's 2021 David Carliner Public Interest Award to Adaku Onyeku Crawford.
Thank you so much. There are so many people I'd like to thank for this amazing honor. ACS and the Carliner family for recognizing me for this important work. Fatima Goss-Graves and Emily Martin for supporting my nomination. Dr. Sean Osei-Owusu for imparting his wisdom and guidance to me during the nomination process. My mother for showing me by example what it means to lead a life in service to others. My father for giving me the toughness needed to weather such a challenging career. And my 3 brothers for their support, humor, and love. And last but not least, my husband, Jim, who was supportive in the most tangible and meaningful way possible, keeping our 3-year-old daughter and then 2-month-old son entertained as I put the finishing touches on my nomination essay. As always, thank you for helping me be great. I'm honored to be accepting this award on behalf of the National Women's Law Center, an organization that fights for gender justice in the courts, in public policy, and in our society, working across issues that are central to the lives of women and girls. For nearly 50 years, NWLC has been on the leading edge of every major legal and policy victory for women. NWLC uses the law in all its forms to change culture and drive solutions to the gender inequities that shape our society, and to break down the barriers that harm all Americans, with an increasing focus on those who face multiple forms of discrimination, including women of color, LGBTQ people, and low-income women and families. Specifically, my work at NWLC has focused on removing educational barriers for girls, with a particular focus on girls who are pregnant or parenting, as well as girls of color. This is work that is both personal and meaningful for me. I grew up as one of 4 children, the only daughter of Nigerian immigrants. I remember being quiet and shy as a child and was interested in learning. I prided myself on getting good grades in school. And although there were many people who told me I was smart, capable, inquisitive, and insightful, there were as many people telling me I was rude, disrespectful, aggressive, and unladylike. Oftentimes, these characterizations came after questioning the purpose of rules that I thought were unfair or actions that didn't make sense to me. Too often, a Black girl challenging the status quo is seen as a threat instead of a demonstration of assertiveness and leadership potential. I didn't know it then, but I was part of a long line of Black women and girls who have been at the heart of movements that have secured civil rights for millions of Americans. Linda Brown's denied enrollment at Sumner School was the basis for Brown v. Board of Education, which ended de jure racial segregation in schools. Lucy Parsons helped organize the first May Day and campaigned to establish the 8-hour workday. From Fannie Lou Hamer to Stacey Abrams, Black women have fought voter suppression and intimidation. Yet too often, Black women and girls have been afterthoughts in both the racial and gender justice movements. At the same time, systemic racism and sexism combine to create unique barriers for Black and brown women and girls. I know that drawing on my racial identity and gender can be a source of power. I have been honored to start my legal career at NWLC, highlighting the dignity and leadership in Black and brown women and girls, and promoting an intersectional approach to the advancement of civil rights to protect them. The years after I graduated law school in 2014 were filled with amazing strides in gender justice. Spurred by the advocacy of student activists, campuses had begun to take seriously the issue of sexual assault. The Supreme Court had made marriage equality a law of the land. The Departments of Education and Justice had issued directives to affirm the rights of transgender students in school. And in partnership with NWLC, activists had begun to connect with policymakers to highlight the unique ways that race and gender-based discrimination push Black and brown girls out of school and perpetuate cycles of poverty and confinement. But a backlash was brewing and actualized in the results of the 2016 election. I knew that recent progress in gender justice would not only stall, but also come under attack. At the same time, I saw a growing desire for younger advocates to engage civically to enforce their rights, but they needed the tools to make that desire real. With colleagues at NWLC, the Let Her Learn campaign was created. The goal of Let Her Learn is twofold. First, to highlight gender and race-based barriers in schools. Second, to give girls and gender-expansive youth of color the tools they need to fight for the schools they deserve. Let Her Learn sought to democratize enforcement of educational civil rights for students who lack access to legal representation. It includes toolkits distributed to thousands of advocates that explains federal civil rights laws using language a middle school student could understand. Videos that show how race and sex stereotypes create hostile school environments for Black girls. It has allowed NWLC to have conversations with Black and Latina girls, identify race and gender-based barriers that these students encounter in school, detail the solutions they propose in reports in which they are credited as co-authors, and provide advocacy training and opportunities for student co-authors to meet with local, state, and federal policymakers. Let Her Learn has helped establish NWLC as an intersectional gender justice organization. It has inspired countless girls and LGBTQ youth to become advocates for racial and gender equity. The most prominent project under Let Her Learn has sparked a nationwide conversation about how one particular practice ingrained in American life promotes race and sex-based discrimination. Co-authored by 21 Black girls in DC public schools, Dress Coded, Black Girls' Bodies and Bias in DC Schools shares stories about students being reprimanded for attire that would, quote unquote, invite harassment, punished for wearing bonnets or Afrocentric headgear, and subjected to gender-based uniform or dress code restrictions that conflict with their gender identity or expression. Dress Coded was NWLC's first foray into participatory action research, which looks at affected populations not as subjects of study, but as experts in their experiences, capable of proposing solutions to the barriers they face. The report had an almost immediate impact. Individual DC schools consulted students to make their dress codes more equitable. DC council members cited the report to pass comprehensive school discipline reform. And last year, Virginia became the first state to pass and sign into law the Dress Code Equity Act. I am gratified that through Let Her Learn, I have been able to combine law and public engagement to bring more people into the policymaking process. But to be clear, I did not do this work alone. The success of Let Her Learn could not have been possible without the ingenuity of my former NWLC colleagues, Nia Evans, Kayla Patrick, and Alexandra Brodsky, who conceptualized Dress Coded and worked covertly to make it a reality, as well as Noelia Rivera Calderon, who drew inspiration from Dress Coded to co-author 2 groundbreaking resources: We Are Not Invisible, No Somos Invisibles, a participatory action report which draws attention to the mental health needs of Latina girls, and Brick by Brick, a curriculum co-designed by queer and trans youth of color to teach LGBTQ advocacy. All 4 of these women would be exemplary candidates for the Carliner Award. And while I fully plan on encouraging Alexandra and Noelia, who are both early in their legal careers, to apply when they become eligible, I'm unaware of avenues of similar recognition for my colleagues Nia and Kayla, who found ways to be effective advocates without the assistance of law school. One is a passionate and uncompromising organizer. The other, a sharp, no-nonsense policy and data analyst. These are both qualities needed in effective advocacy. Yet too often, lawyer-led movements see these qualities as secondary. And worse, people from affected populations without post-secondary degrees commonly are excluded from policymaking conversations entirely. If we are to create more diverse and inclusive movements that reflect the needs of the folks we advocate for, this must change. Social justice requires policymakers to listen to historically disenfranchised voices and govern to their benefit. But it also requires those with power to dismantle barriers to civic engagement. As attorneys, we are uniquely positioned to highlight that expertise comes in many forms. Expertise can come from legal education, yes, but in gender, racial, and social justice movements, expertise is also drawn from the experiences of Black, Indigenous, and other people of color, particularly those who face overlapping forms of discrimination. So I close my remarks with a challenge to you. Find ways to make your advocacy more accessible for non-attorneys. Challenge notions that seek to preserve so-called prestige of legal institutions. Recognize leadership qualities in unaccepted places and seek to elevate those voices for a greater good. Thank you.
Congratulations, Adaku, on a well-deserved award. Good afternoon, everyone. I'm Kara Stein, Vice President of Policy and Program at ACS, and I'm excited to introduce our panel discussion this afternoon on the meaning, mode, and value of accountability, after which we'll be breaking into facilitated small groups to continue the conversation. Our moderator for this discussion is Kimberly Atkins-Stower. Kimberly is a senior opinion writer at the Boston Globe and an MSNBC contributor. Previously the first Washington, D.C.-based news correspondent for WBUR, the Boston Herald's Washington bureau chief, and a Supreme Court reporter, she is a graduate of Wayne State University, Boston University School of Law, and Columbia University's Graduate School of Journalism. She is also a co-host among a quartet of ACS friends on the Sisters-in-Law podcast, featuring Kim, Barb McQuaid, Joyce White Vance, and Jill Wine-Banks in a weekly roundtable conversation on the latest in politics, law, and culture. And if you haven't listened to it yet, I highly recommend it. Kimberly will introduce our panel. Welcome, Kim.
Thank you, Kara, and hello, everyone. It is my pleasure to introduce our esteemed panel for this discussion. Christine Chung is a New York City-based trial and appellate attorney who serves on the steering committee of Lawyers Defending American Democracy, a nonpartisan group of attorneys, former judges, law deans, and other lawyers who have authored open letters and issued statements demanding that elected officials honor the fundamental principles, norms, and values of our democracy. Among other things, they filed a grievance seeking the suspension of Rudy Giuliani's law license. Also joining us is Molly Coleman. She's co-founder of the People's Parity Project and the organization's first executive director. While at Harvard Law School, she worked for a number of legal organizations committed to advancing justice for the most marginalized, and she served as editor-in-chief of the Harvard Civil Rights, Civil Liberties Law Review. Erica Newland is counsel at Protect Democracy and most recently served as an attorney advisor at the Office of Legal Counsel in the Department of Justice. Before joining the DOJ, she served as a law clerk to the Honorable Merrick B. Garland of the DC Circuit, as well as senior policy analyst at the Center for Democracy and Technology. And finally, Rebecca Royfee is trustee professor of law and co-dean for faculty scholarship at New York Law School, where she studies lawyers' ethics and the history of the legal profession, focusing, among other things, on examining the country's tradition of prosecutorial independence, particularly with regard to the president's power to control the Department of Justice. Prior to joining New York Law School, Royfee worked as a Manhattan prosecutor. She served as a law clerk for the Honorable Bruce Selya in the First Circuit. We hope all of you in our audience stay for the facilitated breakout discussions that follow the panel discussion to continue the conversation. Information on how to access the breakout room discussions will be available at the end of the panel and on the ACS website under today's schedule. For those seeking CLE credits for our panel, we will post a link in the chat box at the end of the session, which will take you to a Google form that you must complete in order to obtain credit. You will be required to provide two codes. I will give you the first code in the middle of this panel and the second code at the end. You will need to provide both codes to obtain credit. And we encourage you all to be active participants during this panel. Please use the live comment section on YouTube, located on the right side of this page. If you're joining us via Facebook, you can comment there, or on ACS's website to share your remarks and questions. I will ask as many of your questions as I can during the last section of our conversation. Please note that in order to comment, you will need to be logged into your Facebook or Google account. So I want to jump right into this discussion of accountability with Christine. First, give us an overview about the work that you are doing at Lawyers Defending American Democracy, and what is the thinking behind using statements and complaints in order to seek accountability of the attorneys in the government?
Thanks, Kimberly, and thank you to ACS for inviting us. And I'm honored to join this esteemed panel of women defenders of the rule of law. Not that we're excluding anyone, but it's great to see an all-female panel. The work of Lawyers Defending American Democracy, we're a volunteer organization, nonpartisan, and we took on a mission 3 years ago during the then Trump administration of mobilizing lawyers and the legal community to speak out and act out in a time of crisis, we believe, for American democracy. So whether you're on the right or the left and not impinging on people's right to express political views, our belief is that there are legal limits, there are ethical limits, and that lawyers have a special responsibility to defend and enforce those limits. And so we have now followers in a number of about 14,000 who have signed our open letters, our grievances against former Attorney General Bill Barr and Rudy Giuliani as the architect of the big lie. And I'm gratified to report that there is a lot of, I think, what we find is that lawyers want to have an outlet to speak out and do something to try to defend the rule of law when they see that it is under attack. And we think that we have a lot of camaraderie in the idea that lawyers have special obligations to each other and to the public, and that when times are tough, we need to get out of our chairs and do things to defend our American democracy.
And I want to, as soon as possible, open this discussion so that you all can talk amongst each other. But Christine, I just want to get an idea. How do you decide which complaints or grievances to file and against whom?
So, on Giuliani, it's, we get asked all the time, why did you file the Giuliani complaint? What motivated you? This was back in January, and we filed it about 2 weeks after the January 6th insurrection. And kind of the short answer is that we didn't see anybody else doing it, which doesn't mean that people weren't, because many of these are confidential. And we know that other groups, including prominent groups, like the former head of the New York State Bar, have filed complaints in the New York State courts against Giuliani. But we wanted to pull together a comprehensive complaint laying out what we felt that his ethical obligations were, and to make the point that his ethical violation was, in our view, in the view of many, the most substantial that you can have. This is not stealing money from a trust account. This is not lying in one court pleading. This is propagating the big lie, including in court, but also out of court, and engaging in dishonest behavior that, in our view, renders him unfit to be a lawyer and to hold his license, and to really abuse his license, that he should be stopped from doing that. So we just did it because we felt that it was something that needed to be done. And we got over 7,000 signers, including over 4,000 lawyers in the first 10 days after we filed the complaint.
So Rebecca, talk about the upsides and also the potential drawbacks of seeking these sort of disciplinary claims against administration lawyers and former administration lawyers. Are these cases clear-cut?
Thanks so much for having me, and thanks for that questions, and thanks for the work that you all do, which is so valuable. I think it's not clear-cut, and here's why. Basically, when you have official misconduct of any sort, everybody wants accountability, and that's a good thing across the board. But this particular form of misconduct has taken the form of an attack on our institutions, the liberal institutions of democracy. And so I think there's another goal that we have to keep in mind, which is protecting, preserving, and strengthening those institutions. And so in order to balance those two goals, the goal of accountability with the goal of preserving the legitimacy of our institutions, we have to do, in my mind, two things. We have to be very consistent and fair on one hand. And secondly, we really have to adhere carefully to constitutional norms. So in this context, that means two things. We have lots of really broad rules, ethical rules. I teach my students, we have a rule against deceit, dishonesty, and misrepresentation. But the thing is, that rule is not applied across the board to any lawyer who lies. We all know that. I mean, people lie in their personal life, people lie on TV, they don't face these kinds of consequences. So my cautionary tale is we shouldn't go out on a limb here and apply this rule in a novel way in this particularly politically charged setting. If we do that, we threaten the legitimacy of these professional responsibility rules that are so critical to the rule of law. Secondly, in terms of adherence to constitutional norms, I think it's extremely important that we're careful about that. And look, this is core political speech. When a lawyer is speaking out about problems in the within government, that is core political speech. Now, some lies are protected by the Constitutional First Amendment. That's the way our system works. Now, lawyers are subject to greater regulation in terms of their speech than others. But it's not just because we treat lawyers differently, it's because we think we have a compelling government interest and that this regulation really furthers that interest. So in this context, I just think we have to look out for what is that interest. And some of them have already been mentioned. Maybe we think these lawyers are unfit. They will lie to their clients. They won't they won't be a good lawyer anymore, fine. If that's a compelling state interest, that's fine. Or, maybe this is about the integrity of the profession. Maybe this is about people not losing faith in lawyers entirely. All I'm cautioning is that we have to think about these things very carefully before we go forward, because it's not a simple case. Just because there was a violation of the rule doesn't necessarily mean that we want to apply it or we should.
I want to turn to Molly to tell us about the ways the People's Parity Project is seeking accountability. It's outside of the normal professional disciplinary landscape. Tell us a little bit about that work.
Yeah, thank you for the question, and just echoing the enthusiasm for this panel. Really, really grateful to be here for the conversation today. So at the People's Parity Project, our fight for accountability within the legal profession started long before this post-Trump reckoning with what the Trump administration's lawyers were doing, which is the topic of today's panel. We've been thinking since our founding about what is the role of the legal profession to hold accountable all lawyers who work to undermine our legal system, who work to use the power of their law degree to harm the marginalized, further oppress the vulnerable, to shut off access to our courts, to our civil legal system. What does it mean to exist in a profession when lawyers are rewarded for having power, regardless of how they use that power? So we've been thinking about what does it mean for lawyers who use their degree to help companies bust unions to be rewarded, to be honored in this profession? What does it mean for us, even in the progressive legal space, to lift up lawyers who have dedicated their careers to slamming the courtroom door shut, to plaintiffs, to class action lawsuits, to those in need of justice, in need of legal remedy? And so I'm gratified that this conversation is happening today, but I do think it's important to recognize that the need to call for accountability, to really enact accountability when it comes to the most heinous actors in the Trump administration, the legal architects of the worst horrors of the last 4 years. This conversation, from our perspective, needs to go far beyond that. We believe that it's time for a real reckoning with how the legal profession rewards certain behaviors, who we lift up, and who we choose to hold accountable. That said, of course, the most urgent part of this conversation is in how we respond to the Trump administration's lawyers. And I think while so much of this conversation today will be focused on the possibility of ethical sanctions, disbarment, even criminal charges, what we're focused on at PPP is an even more basic question, which is not how do we penalize these actors, but how do we stop rewarding these actors? What does it mean to stop? What would it look like to stop saying, you are the architect of the child separation policy, here's a multi-million-dollar position at a law firm? What would it look like to say, you were engaged in harmful actions that undermined our democracy, and so you don't get to be a tenured professor at a law school? That is a position that is available to those who have used their degree to advance justice, for those who represent the very best of the legal profession, not the absolute worst, which is what we're talking about when we talk about many of the Trump administration's lawyers. So at PPP, we're thinking about what does it look like to change that culture? How do we organize within the profession to create long-term change? How do we ensure that when this moment passes, when we're a couple of years out from the Trump administration, when we want to stop talking about the child separation policy, when we want to stop talking about everything that's happened over the last 4 years, that we don't forget who was involved in that, and that we continue to say that if that is how you used your law degree, you're not welcome in these spaces. You don't get to guide the next generation of lawyers. You don't get to shape our law through future positions in government or at powerful law firms. So at PPP, for a concrete example, one of our, actually a report that we have coming out in the very near future is taking a sampling of the Trump administration's lawyers, detailing what it is that they did while they were in government, and then talking about where they are now. We're looking at 23, some very high profile attorneys in the Trump administration, some who are certainly not household names, people like Earl Comstock and others who, frankly, is not a name that rolls off of my tongue. And looking at where are they now? What positions do they have? How are they further shaping the law, further shaping the legal profession? We found that half of those attorneys that we're looking at have landed back in private practice, many at some of the largest and most important law firms in the country. some of them are still in government, where it isn't seen as disqualifying that they engaged in these horrors over the last 4 years. So for us, it's about documenting, it's about changing the culture, and it's really about how do we stop rewarding this sort of behavior throughout the profession.
So Erica, you have worked on the inside of the Justice Department. How do you see these efforts? And do you think there is a risk with this new focus that well-intentioned attorneys who were following the directions of their supervisors might get swept up and held culpable for actions that they didn't spearhead?
It's a great question, and thank you. I want to echo everyone else's gratitude for holding this panel and this conversation. Attorneys are in the business of holding other people accountable, right? That's our bread and butter, especially those who are on the prosecutorial side and or on the plaintiff's bar side. And I think it takes some chutzpah for us to suggest that the same rules don't apply to us. And to kind of lift up a point that Molly made, we as a profession right now, I think engage in kind of a gentleman's club mindset of lifting each other up, regardless of, independent of the substance of what we've done with our professional degrees and with our moral agency. And so when I reflect on my time in government, what I reflect on was a real sense that I think had been trained in people of not having moral agency, that we are but cogs in the wheel. I think that it reflects a failure, whether that's a failure within ourselves, of law schools, or maybe of early legal training, and an opportunity for reflection and for further education so that attorneys can kind of feel that moral agency and be empowered and feel empowered to make different decisions. And that's a long way of getting back to your question, Kara, and saying, I think we are so far from the pendulum swinging too much that it's not something that concerns me. We can have that conversation when innocent people are losing their jobs for the wrong reasons. What's happening right now is Rod Rosenstein, who said no child is too young to be separated from their family, is back at his law firm and has been elected to the American Law Institute. And that's what I think is worth.
So I want to open it up to all of you a little more and ask some broader questions. I mean, we have the disbarment and attorney disciplinary scheme that's set up in each of the states where attorneys are licensed, but certainly that's up to them. That's up to those disciplinary bodies to act, and it's not really up to anyone else. We have seen a lot of the people leave the administration and not be disciplined as of yet. So what does real accountability look like? Is it the job of the federal government? Is it the job of law enforcement? Is it just to be left in the hands of organizations like yours? Talk a little bit about how you would like to see the levers of accountability look, and what changes you'd like to see. I'll start where I left off. I'll start with you, Erica, again.
I think it's all of the above, Kimberly. It starts, I think, socially. It starts with who we are welcoming into our community of attorneys, to Molly's point, who we are lifting up. It also means bringing litigation when there has been wrongdoing that rises to the level of litigation. Protect Democracy right now is litigating a case against Donald Trump. I don't want to make everything about Trump. Let me be clear about that. For his role in the insurrection. It is, and supporting a January 6th commission to also focus on accountability and preventing recurrence around insurrection. But I want to just really emphasize the point before handing it over that it's on each of us and us within our collective professional peers groups to decide who we are rewarding and welcoming. I often think about the Mueller report and how we were all, I think there was a collective, like, this is Bob Mueller's problem to deal with, when in fact Trump was not Bob Mueller's problem. He was something that we all had to deal with.
I'll just jump in to say, I think there have been a lot of important points made, but I think we have to be cautious, especially as the world silos increasingly, and we have to be careful that what we're doing is in fact shutting down inappropriate, unacceptable, unlawful, unethical behavior, and not shutting down opposing views. And I think that it blurs from time to time. So one thing I would say is that I'm very concerned about when that form of accountability, the one that Erica was talking about, where we're really talking about a kind of professional reputational consequences. I think that it is fine to hold people responsible, to think about, who did you choose as your client? What did you choose as your case? And I teach my students, think about the choices that you make. However, there's a line that I would not cross, and that is the line where it becomes, there were organizations that will remain unnamed that were posting the names and telephone numbers of certain attorneys that were going after them, that were threatening in certain ways lawyers who were representing clients that they did not agree with. This is a core, important, fundamental part of democracy that we need lawyers to represent extremely unpopular positions. That doesn't mean you have to do it, but it means that we can't be so harsh that no one will do it. And so open the conversation, don't shut it down, is my point here, which is, yes, absolutely, make people think about and talk about and justify decisions that they make, but do not act in such a way that you are actually engaging in something that, I would say crosses over into shutting down dialogue and rejecting in a way that you are essentially cutting off a conversation that ought to be had.
I want to turn to Molly in this because it seems, especially when we're talking about protected speech, when it comes to any sort of state or government action, you have that sort of built into that process. But with private firms like law firms or other private companies, you don't. These private companies have the ability to act or not act accordingly. So Molly, is there a concern that Rebecca brought up about sort of going too far? What are the limits there?
Yeah, so I take the point. I do think, though, to go back to something Erica said, we are so far from the pendulum swinging that far. We are talking about generally law firms who are competing for this business. There is the notion that we are at a point where we've made certain behaviors so off limits that there are rich and powerful people or rich and powerful companies who can't find a lawyer. I don't think that we are anywhere near there. I don't think that there's evidence that we'll reach that point anytime soon. What I think this is about is, and to Rebecca's point, that it's about the fact that there are trade-offs, and that when people are making the decision, weighing the pros and cons of taking a certain client or engaging in a certain type of lawyering, they have decided that the trade-offs are worth it. And I think, frankly, that's often been because there hasn't been adequate pushback. There hasn't been a concentrated outcry within the profession saying there is real harm that you are doing. It's been, you can make a bunch of money doing this, you can access privilege, you can access power, you can be in these elite spaces, and nobody will question what you're doing because, again, to Erica's point, you're just a cog in a wheel, you have no moral agency, and we don't get to talk about who's hurt in your quest for power, for wealth. What we're arguing is that we need to talk about that moral agency. We need to talk about the harm caused. And people might still, and I expect that because of the way this profession has long been, people will continue to make the decision that that representation, that work is defensible, that they can sleep at night. But we want to make sure that like I've said, it isn't rewarded and that they are making that decision with a full awareness of the moral agency that they have.
And Christine, I want to bring you into this too, to sort of talk about where you see the pendulum. Do you agree that it hasn't swung so far as to worry about the other side, or do you have concerns there as well?
No, I think we're talking about core principles of accountability and line drawing, and that we're not anywhere near a margin or a border with the people that we're talking about. And you don't have to take our word for it. Look at the people who stepped back from representing Trump. Okay, So it's easy to be pessimistic about accountability. I certainly am. But I also think that a silver lining is that getting lawyers to speak out and represent their profession on what the boundaries are does have effects, salutary ones. And we should all take heart in that. You know, as a former federal prosecutor, I'm gratified that I think where many of the architects will end up is being indicted. These are not morally otherwise, good people or legally otherwise good people. They've all lived on margins of their own. But I do think that lawyers in a time of democracy being under threat, you have to, if government fails and institutions are threatened, professional norms are incredibly important. Lawyers, giving in was part of how Nazi authoritarianism happened. Doctors agreeing to perform unethical procedures is part of how that happened. Businesses deciding to use their businesses to transport Jews or ovens to kill Jews is a way that happens. And I don't think that, I wish that this was a more far-fetched analogy than it is, but the point is that I don't even think that it's lawyers being cogs in a wheel. I would strengthen it. I think many lawyers feel privileged and that it's never going to touch them. And that is not the right attitude to have. I think that lawyers need to acknowledge that, even the preamble to the model rules talks about how lawyers have an obligation to promote respect for the law. These are very not making frivolous arguments. Discourse is one thing, lies is another. Deceit and fraud are well-defined terms. There's no constitutional void for vagueness problems in any of that. So I really reject the idea that we're on some fringe idea here. The problem is that there aren't enough lawyers in the middle who are willing to step forward, and really we need like a new civil rights revolution of everyone, where everyone is included. And I think that lawyers really need to understand that and get more involved.
I want to ask a follow-up question for you, Christine. But first, I want to say to all of those joining us who seek CLE credit, the first code for today's panel is Legal 9. That's Legal 9, which you can also find displayed at the bottom of the screen. As a reminder, you'll need this code and the code I'll provide you at the end of the panel to qualify for CLE credit. So Christine, you at the beginning of your last answer, you led me to a question that I wanted to go to soon, is when is criminal prosecution, when is that the right thing to do? When is that warranted? And when is that responsible? And how do you do that without looking as if the current administration is punishing its political enemy in the form of the previous administration?
Well, that too is a dialectic, right? Because there's also nobody is above the law. And so, yeah, I mean, to go back to the Giuliani example, he already in some sense has gotten preferential treatment. They wanted to take his records in the last administration and DOJ decided not to do it. And so his investigation is being drawn out longer than it probably otherwise would be. So I totally acknowledge, I myself don't love it if Giuliani and Trump indictments come closer to the next presidential election. I think that's going to be really problematic. But at the same time, you have to make sure that, anybody who commits insurance fraud or tax fraud is prosecuted under the same principles, even if they're powerful or political people.
Anyone else have thoughts on criminal prosecution and potential?
I just want to jump in here because I recognize and fully respect the passion behind these statements. And I agree with you and have been writing about the horrors of this administration. But I'm going to go back to this cautionary tale. Look, historically, it's who do we trust? Who do we trust to bring other people to account? And, we need a healthy skepticism even as we hold the levers of power. And I think increasingly we do, but we set precedent by holding them. And, it wasn't that long ago that people were going after lawyers for representing members of the Communist Party or people who opposed World War I and disbarring them for those representations. And I I don't think we're there yet, but this is not, these protections are there for a reason. They're there to keep us very, very far from that line because we never know when we cross it. And so what I say is consistency, consistency, consistency. The way that we can avoid allegations of being politically motivated is by remaining consistent. Do what we have always done, follow the policies that we have always followed. And if we can apply the law to the fact in that way, we hold every person responsible. But we don't do some kind of crazy novel, like prosecution of some crime we never, have prosecuted before, or is rarely prosecuted, or is somewhere weirdly on the books tucked somewhere. And we can do that. Prosecutors can do that, but they need to be very careful that they're crossing their T's and they're dotting their I's, because then when somebody comes at them and says, hey, this is just because you're a bunch of Democrats, they can say, nope, look, I showed my work here. And it's exactly the same work that was done when it was a different person in that seat. And that's the way that we ensure that we don't open ourselves up, even if that's not what's going on, open ourselves up to that accusation that will fundamentally erode these institutions that we need to last for a very long time and are in jeopardy right now, are being pulled apart from both sides. So I'm not saying that means don't hold people accountable. We may be able to, but some people who did terrible things may not be held accountable because we have to do that.
So if I can jump in and couldn't agree more with Rebecca about the importance of crossing our T's and dotting our I's on any accountability efforts. I do want to push back at the idea that what we want to be doing is holding the line in a very conservative way on everything that has led up to this point. I think we got here because our forms of accountability were not sufficient. I was at the Office of Legal Counsel. I was working with folks who were engaged in torture and not in justifying torture. The head of the office did not receive John McCain's vote because of that, and yet he was brought back in to lead the office. There hadn't been accountability and facilitated some of the Trump administration's worst abuses. I think we can look at Donald Trump himself and say that he was someone who should have been prosecuted a long time ago for probably tax fraud and other things based on what's been publicly reported. And that maybe a failure to hold elite actors across the spectrum accountable has led to not only our current political problems, but some of our current social and economic problems as well. I also want to emphasize that, in my mind anyways, accountability is not just about calling out the people who've done wrongdoing. It's also about lifting up the people who've done the right things. And that's a really, really hard thing to do when the folks in power are engaged in wrongdoing. I have some personal heroes from across the Department of Justice from my time there who, I can't raise up their names because that wouldn't be doing them any favors. But finding ways within the profession to lift up those people and make sure that the people who do have that sense of moral agency are awarded, even when professionally maybe they're not. When at the workplace we can't reward them in the same way.
Eric, I want to ask you, since you did work inside the Justice Department, one of the points that Rebecca was making was about consistency. And one thing that we have seen happening in the Biden's Justice Department, the Biden administration's Justice Department, I know it doesn't belong to him, but is a continuation of some of the policies, the continuation of the opposition to releasing some of Bill Barr's memo surrounding his characterization of the Mueller report, continuation in representing Donald Trump's side in intervening in the civil lawsuit of E. Jean Carroll, for example. Is that speaking to consistency? And do you and any of our panelists have concerns or thoughts about that?
I have a lot of concerns about that. I don't know what went on within the Department of Justice around the decision making there, but I think it reminds us that this vision of the president as king was being sown, or the seeds were being sown long before the Trump administration. That the idea that the facts don't matter when the conduct of the president is at issue was, the ideas for that were being planted long before the Trump administration, and Democratic administrations have carried the torch on that. I think it's very concerning, and I think it's something that we as progressives should be pushing back against. And I don't think it does anyone any favors. I don't think it does the presidency any favors. I think it undermines the legitimacy of the president, no matter who that president is.
If I could jump in, I think that what much of this conversation has turned to is what precedent are we setting? What precedents led to what we saw over the last 4 years, and what precedents are we setting now? And I think that this question of how do we ensure that rules, standards, criminal enforcement is applied equally is important. It's critical to ensure that we don't go back to the point, to what we saw in the McCarthy days. It's also critical that we set a new vision for what the norms could be so that we don't find ourselves back here after the next Republican administration having an even harder conversation about even more abuses of power. I don't know if folks are following along in the chat, but looking at the conversation that's happening there, the Trump administration was not an outlier in much of what they did. In many ways, they were building on what was seen during the Bush administration and the lack of accountability that we saw after the Bush administration. So, I think about what are we telling the next generation of lawyers? I work with recent graduates, I work with law students, and I hear how this is impacting their conversations. It's impacting what happens in the classroom. If we continue to tell lawyers that you are above the law, that you are above even social repercussions for any behavior that you engage in, what does that tell the next generations of government lawyers, of corporate lawyers? And what will they think that they're able to get away with and that they should not face even the slightest condemnation for? So that, I think, as we talk about this conversation about what are we setting ourselves up for down the road, I think that has to be an important part of the conversation.
I know I'm taking up a lot of space here, but I want to echo a point that Molly made and say, ICS is living on borrowed time until Trump 2.0 or Trump 1.0 again is in office. And I think it is incumbent on us as progressive attorneys to think about how we empower the folks who are going to be at the Department of Justice and around the federal government at the time to do the right thing. And we build that now, and part of that is building the vocabulary.
I also just want to throw in there the federalism concerns. So I actually think that there does need to be a lot needs to be done in terms of Office of Legal Counsel, the Office of Professional Responsibility, the Inspector General, but I would move things in that direction over state discipline because, I think it opens up, it's just very difficult for the way that our federal system works to have state courts deciding these questions. And I know, that's our system, but it's not our only system. And I agree that there are major problems in terms of the way it works in the federal government, and I'd rather see that fixed than channel these things into state bars.
I just wanted to give Christine a chance to chime in before I go to some of our audience questions.
It's not an either or. I mean, listen, there's a huge variation in states, so that it's not, but it's not like we're going to the state bars because it's a first choice or the most effective thing. And in many instances, it's because people look around and they say, who is going to hold William Barr accountable? And there aren't that many options, and they should all be used.
Okay, I want to go to some of our audience questions. As I said, I love this one as a former litigator myself. Here's something I wondered all throughout the Trump debacle. What happened to Rule 11? Is it one of those first things we learn as a 1L? Why bother if it doesn't exist in reality? Talk about Rule 11 sanctions here.
Can I just jump in about Rule 11 for 1 second? Sorry, it's just that I want to say a couple of things. First of all, that's another thing is that these cases, there are very few disciplinary complaints under Rule 3.1, which is the professional rule equivalent of Rule 11. These are taken care of by courts, and there's a reason for that. That's because courts are in a better position to do that. So, that's a total non-answer to your question, except for saying that I think the right institutional actor and the institutional actor that's done this before is the one that should do it now because of consistency. But why didn't they? And I know this is going to be unpopular, but I really think they didn't because this was actually a good thing. The fact that these things were brought ultimately were a way in which this particular crazy viewpoint that was not created by lawyers was funneled through courts, and funneling it through courts was a way in which we used an institution that people still believe across both aisles, not all of them, I know, troublingly, have some credibility. So that when 60, whatever it was, courts came out and said there is no massive fraud, it did convince a significant number of conservatives. And if we hadn't had that, I'm not sure January 6th would have come out the way it did. So I don't know that we want to deter over deter a lawsuit that is about a critique of government, because there is a way in which this is actually a very good mechanism to resolve, something like this. I wish it never arose, but I don't know that lawyer discipline is the right way to prevent it from happening again.
So I would say Rule 11, one reason it didn't occur, I don't want this to become a Civ Pro lesson for those students out there, but a lot of the complaints got dismissed because the judges did their jobs. Most of them did. But that means that under Rule 11, basically the litigation was so fast moving, it outstripped some Rule 11 possibilities. And the other thing is Rule 11 is only federal, right? So a lot of the cases were brought in state courts. With the Giuliani complaint last month, very interestingly, Governor Wolf of Pennsylvania and the Pennsylvania AG joined the call for an investigation. And they pointed out the harms to the state of Pennsylvania, which they characterized had borne the brunt of the big lie election litigation. And among other things, they pointed out that it cost them $3 million in external lawyers. Their workers were threatened, including with death threats, that didn't even begin to account for the trouble and the damage to their reputation and the integrity of their elections that was done by the big lie. So Rule 11 has its place too, everything, all of the above. But there are reasons why in election litigation, at least, Rule 11 really never got a toehold. You have to give notice. The most usual remedy is the dismissal of the pleading. And in these cases, that was already done. And a lot of states and municipalities don't have the ability or the resources to go back to the well and ask the judge for sanctions. So I would love it if Rule 11 were more used. And in fact, it was in Michigan. The city of Detroit did bring a Rule 11 motion. I don't know where that stands now. But again, I think the answer is, no one mechanism is nearly effective enough. And so that's why you see people going to these other mechanisms.
Another question from our audience. Should state bars have any role in dealing with the systematic lying by lawyers underlying the election challenges and now the audits that are playing out in places like Arizona? This is something that I am asked a lot of the time, and I think a lot of people in the American public are wondering why state bars can't come in and act when lawyers are clearly lying about fundamental democracy.
Listen, I think that the legal norms that we're trying to enforce are not remarkable. The conduct is. And so state bars, like everybody else, are sort of catching up to the idea that, hey, big lies succeed better than small ones. And it's almost so obvious, but, state bars are different. We got a letter back in response to the bar complaint saying, we consider this to be about a public figure and we generally don't get involved in, I'm going to quote it because it's kind of remarkable. We get complaints from time to time about public figures. We don't intervene in matters that are currently and publicly being discussed in the national political arena.
Wow.
Okay, that's immunity. That is not norms and enforcing, very standard lines. It's saying, if I can call it political, I'm going to shove you into the outbox. And so in terms of state bars, you're going to have a huge amount of variation. On the other hand, in New York, Andrew Giuliani recently came out and said that his father needs money from Trump. And one of the things he listed was to defend, he mentioned two things: the criminal prosecution, the criminal investigation, and the bar grievance. And so, listen, one effective thing about the bar actions and state bar committees is lawyers realize it's their livelihood. Losing your law license or being at risk of it is not fun. And that's why a lot of people step back from representing Trump and the big lie.
All right, another question from the audience, we have a lot of them. Is Attorney General Garland incapable of resurrecting DOJ's honor? Progressives are calling for his resignation, saying that he's not close to being up to the task per DOJ's recent positions that we were talking about earlier today. That's another question that's sort of like Christine was just talking about, this intersection between law and public opinion and public perceptions. Is that something that plays a role here in what happens within the DOJ?
This is for Erica, I think, this question.
I can go to Eric, but anybody can chime in, but I would love to hear from Erica, yes.
I want to move the question away from Attorney General Garland and toward all of the attorneys at DOJ, who I think have a duty to make sure that they are standing for the best of the profession and for facts in a way that attorneys at the department didn't always during the Trump administration. I think it is very natural for attorneys within government, in order to promote those values of consistency, to try to give every benefit of the doubt to the prior administration. And I think those presumptions of regularity here do not stand. When we have example after example of the Trump administration lying to the courts. I'm thinking of the census case. I'm thinking about the New York Global Entry World Traveler case. I'm thinking about the recent litigation over the Bill Barr OLC memo. And so my hope is that the department is recognizing that, as I think Jake said in the chat, that these are unprecedented times, and that you have to look very closely at the facts. Lawyers always engage in the facts when it's other folks, and then we need to do it with ourselves.
I would just jump in and give another historical example, which is, what happened after Watergate. And really this notion of prosecutorial independence and the independence of DOJ has been around forever, but, grew up and really got traction right after Watergate. And after Watergate, there were a series of attorneys general who were extremely professional, extremely focused on keeping their head down and doing things in a kind of bureaucratic, boring way. And, that is an antidote to some of these problems. That is in some ways what we need. It is disappointing to people who are looking for results, and it is disappointing to people who are looking for accountability, but sometimes it is the answer. And so, I don't know, because I don't have the benefit of hindsight with regard to Merrick Garland, but I do know that in terms of after Watergate, those series of attorneys general did their, they managed really well. I think we need some more permanent changes, seeing how rapidly things turned around. Just as Erica was saying with regard to internally within DOJ, I think we need some things to happen, absolutely. But part of what we need to happen is to put some good professional people who may not, please, certain political crowds, but will put the department back on track in certain ways that will reassure the public that, the whole thing isn't corrupt.
And I'll agree with Rebecca 90% of the way there, which is I think the facts are going to speak for themselves. I think you follow the facts with independence, and I don't think that's inconsistent with likely to be inconsistent. I don't want to prejudge with certain forms of accountability and restoration of the rule of law.
Yeah, absolutely. And Nixon had the advantage. I mean, in Watergate, there was the advantage that he resigned. This thing, which is his, the second act of Trump, didn't exist then, and that made that political moment less complicated than the current one.
I want to ask a question. I've seen similar questions from our audience, so I'm sort of paraphrasing that one and my own. But what about other avenues for accountability? I'm thinking about things like the defamation suits that were brought in the wake of claims made by certain attorneys about voting machines and alleged election fraud that didn't happen. I'm thinking about the civil suits that are brought by civil rights groups over the treatment of protesters and the decisions by the DOJ that led to that. What about civil suits as a form of accountability for lawyers?
Well, to take Dominion as an example, I think that was much more effective in actually stopping Rudy from making the statements that he was, because even after, as recently as a month ago, or basically if you track what he was doing on his YouTube channel and on his show, he continued to disseminate very sort of flagrantly the big lie until the Dominion suit was brought. And when your lawyers and friends tell you that you are on the hook for $2.1 billion, it does have an effect that some of this other stuff does not. But But that's kind of chancy, right? I mean, they were very directly spoken about. They were able to allege damages, according to them, with not enough specificity yet. But again, it's like part of the menu. And I think in some ways, the private suits are showing that they're the most effective things in terms of deterrence. It's a little bit on the nose. So I never think of those as perfect mechanisms of accountability, but they're certainly having their own effect in this mix of things.
Yeah, I mean, I would add into the mix also in terms of alternative kinds of accountability, this question of reputation that I think we were talking about earlier. So just to circle back to that question, I think, in some ways it definitely could have worked better, but in some ways it was like a lot of law firms did pull out, as soon as they saw what was going on, they Jones Day was like not having it. And the president was left with lawyers who a lot of people looked at that and said, look who he's left with, like the people whose reputations, this kind of like it's like a market theory of accountability. And again, I'm not saying it alone is enough, but it is working on a certain level that lawyers who were concerned about their reputations were staying extremely far away from this.
I could jump in with apologies for the massive sunbeam behind me. Beautiful weather here today. I think that this goes to something that was brought up earlier, which is that we need to have every tool in our arsenal when it comes to what accountability looks like for the lawyers in the Trump administration. The harm caused by each of the hundreds of lawyers that we're talking about today was not the same. The ways in which they went about their work was not the same. The extent to which they've opened themselves up to criminal or civil liability versus bar discipline versus social sanctions is not the same. And so, I think absolutely civil litigation, bars, it should all be on the table. It all must be on the table. I do, and certainly I here as the proponent of social sanctions and professional consequences and reputational consequences, we also have institutions that are responsible for this oversight, this governance. So while I certainly think, and I think this was Erica who said this earlier, that it is on every single member of this profession to hold lawyers who cause harm accountable, it is also on our governance bodies, it's on our government to ensure that there are consequences when certain lines, certainly legal lines, ethical lines are crossed. And it can't be left up to every individual member of this profession. We have other jobs. We have other things going on. And there are people whose job it is to ensure that there is a price paid for what happened over the last 4 years.
We only have a couple minutes left, so I'll start with you, Molly. I wanted to ask all of our panels if you have any closing thoughts for our audience on this issue.
Yeah, so one thing that hasn't come up, but I did see come up in the chat that I just want to throw into the conversation, or it's come up, I guess, in passing, is this question of line drawing. How do we ensure that we're not equating a Bill Barr with a junior Department of Justice attorney? And that's critical. And it's something that I will say we think about in our work at PBP quite a bit as we're thinking beyond the Trump administration when we're talking about accountability, but accountability for what corporate law firms do. Is it the same to be a partner in a law firm dictating, choosing the firm's clients, dictating the firm's strategy, as it is to be a first or second year associate? Certainly not. We all recognize that there are different levels of moral capability, but when we're talking about the junior attorneys, their actions, their career paths will be influenced by how they see their supervisors, the heads of their departments, the heads of their offices held accountable or not. So while I think that we absolutely need to make sure that we are doing careful, intentional line drawing, we also need to think about how are we, as always, influencing the next generation of what will be considered acceptable, what will be considered lawyering for justice, and what will people think that they can get away with.
Okay, Christine, final thoughts?
Yeah, I would encourage all you lawyers out there to look to your own legal communities and to the organizations that you consider to be legal leaders. So if your bar organizations are not doing enough, if you're a member of an affinity organization who may be affected by voter suppression efforts, your law schools, your law school leaderships, your law firms. There was an important law firm initiative recently led by Brad Karp, who's the chairman of Paul Weiss, saying committing law firms, and there was a long list of them, most of the powerful Wall Street firms, committing themselves to opposing voter suppression. Black Fortune 500 executives also issued a very important letter that was in the New York Times. But all those things need follow-up and reinforcement. And if you're a lawyer, you're a member of some legal community, and try to get your legal community to act.
Rebecca?
So, I mean, I probably sound like a broken record at this point, but I think, what we need to do is have clearer policies and procedures so that when somebody violates one of those, it is clear that maybe they're doing, that's a big red flag. I mean, it happened when Bill Barr stepped in and, he thought he was policing politicization of the DOJ. That's what he would tell you if he were here right now. And the reason we know he wasn't, or if he was, he was doing it in the wrong way, was because he was violating all sorts of policy. You don't normally step in some sentencing after a sentencing recommendation. So we need more things to be written down and clear. We need to have internal DOJ policies that are clearly written out, and they have to be followed so that when they are broken, we can look to that and we can say something happened here. And so I'm all for that. One thing that happened after Watergate where, who can call who about particular cases. Let's strengthen those. Let's come up with more of them so that we can police this internally and we can make sure this doesn't happen again.
And Erica, the last few seconds go to you.
I think you see aggressive agreement here that rule of law is an ecosystem, and that 4 or 8 years from now, we don't want to be looking back and saying, how did we fail to use the levers in that ecosystem to better empower people to push back within DOJ, do the right thing within or from the outside if we end up in this situation again. Protect Democracy is going to be working to build that out over the next year, and I hope that everyone in the progressive community is doing their part as well.
All right, we have reached the end of this discussion. For those seeking CLE credit, the second and final code for today's panel is Ethics 13. That's Ethics 13, which you can find displayed at the bottom of the screen. As a reminder, you will need this code and the code I provided earlier to qualify for CLE credit. Use the link posted in the chat box, which will take you to the form you must complete. On behalf of ACS, I thank all of our panelists once again, and I encourage all of our attendees to continue this important conversation now with the wonderful facilitators ACS has lined up to lead the breakout discussions. To access the Zoom breakout rooms, please use the button at the bottom of the screen or the link you will see in the chat box. See you in the breakout rooms.